Hello everyone, and welcome to Township Tuesday. In the last, sort of since I've been here, but really picking up in the last couple of weeks, I've been working on issues relating to annexation. So what I wanted to do was to start out today. If any of you were at the district meetings, you'll remember Jeff had a call for pictures of your worst roads. Well, I've got a version of that for myself. If you have an annexation horror story, if you know someone who has one, please let us know. We're kind of trying to turn up the heat on annexation reform this session. Obviously, this is a long-term process. It's something that takes a fair amount of fighting, and the cities really like it the way that it is. So we can't guarantee any results, but the things that help are our input from you guys, especially instances of cities behaving badly. Now, in the last couple of weeks, what I've been doing is essentially there's a special court. It's a quasi court called the Office of Administrative Hearings, and that's run by the state of Minnesota, and it handles these disputes for the most part. And so I have been going back through years of their records and just sort of pulling every case that I can find, trying to look for examples of cities behaving badly. And boy, we got a couple. I've had examples of a city failing to tell a township that certain land had been annexed. I've got a city deciding they didn't like what the neighbors were doing, and we're just like, you know what, we're going to take it. And so I'm looking for these stories. These are going to be things that I'm going to be bringing up with legislators to try to convince them to give us more of a say in this whole process. But it'd be really helpful if I could hear from you guys, since I'm only one guy, and what's in your memory banks is covers a lot more ground than I'm able to do. So if you've got one that you think it will be a good fit, give me a call or email information at MN Townships or me, gbergmoberg at mntownships.org. So since I've been thinking about it, I figured we'd do just sort of a brief overview with a focus on the rules that we find particularly problematic here at the association. Now, if you're taking the 10,000-foot picture here, there are three ways that this goes. The first is annexation by ordinance, and that's what we're going to be focusing on today, because that is, in my view, the source of a lot of the problems with this process. Now, I'm mentioning the other two because it's my job to make sure that you guys don't take risks accidentally. You're a policymaker. You have to take risks. It's in the nature of the business. You can minimize it all you want, but you don't want to do it. You don't want to do it blind. So mostly I just want, in case this comes up for you, I want your little antenna to go up and be like, hey, wait a minute, there's more to this process. I need to ask a couple of questions. I'm going to call the association. I'm going to email the association. I'm going to look into it. But mostly what we're going to be talking about today is annexation by ordinance. Now, within this process, there are 7 kinds of ordinances that qualify. So this is governed by Minnesota Statute 414.033. And if you've been to one of my presentations before, this would ordinarily be where I put the whole statute up on the screen so you could see it, or at least the operative parts. But this guy's kind of a monster, so I didn't think that would be worth anybody's time. Monster is too strong, but definitely don't want to have folks just sitting here and trying to read 10 pages of dense legal statute before I go on talking. So here, this is my boiled down version, which has the advantage of of being easier to comprehend and the disadvantage of being less precise. So as with everything that we talk about today, if you have an issue like this, please don't hesitate to give us a call. Please don't hesitate to talk to your own township attorney. This stuff is complicated, and it's potentially pretty expensive if things go badly. So this is an overview. But you got to get an overview so you can get a lay of the land to do your job. So 7 kinds of ordinances by which a city can annex land at a township. Now, most annexations are accomplished through the adoption of an ordinance by the annexing city. Minnesota Statute 414.033 sets out different kinds. Some of these allow the town to challenge the annexation. Some require hearings. Some require the annexed parcel to touch the city. But each one is a little bit different. So we'll just start going through them here. Now, every one of these, as the name says, begins with an ordinance from the city. So in this case, this first one, city-owned land, is pretty straightforward, and certainly not one of the ones that I would identify as particularly problematic, though I'm sure it has room for abuse should a city decide to do that. So this one comes from 414.033, subdivision 2 in parens 1. The city can annex property if it owns the town, or if it owns that property in the township, if the property is deemed to be urban or suburban in character, or is about to become so, and the city has to abut the township land to use this power. Now, they don't need to give us a hearing on this one, and we have no power to object. And for those of you who are particularly quick on the uptake, you might be asking to yourself, so what makes a particular piece of land urban or suburban in character, or quote, about to become so, unquote? And that is the million-dollar question. There is no definition in the statute, which means that there's plenty of room for people to disagree, which means there's plenty of room for the cities to club us with this. But really, the fundamental limitation on this one is that the city has to own the land in question, and it has to abut the city's jurisdiction before it can do this. So this one is relatively rare in my sort of exploration of the cities of the Office of Administrative Hearings docket. I've gone back about the last 5 years now, and we're talking like 10% of annexation cases tops on this one. The next one is surrounded land, which means the city can annex if the property is again urban and suburban in nature, or if it's about to become so. If the property is surrounded by land within the city limits, and this one comes from subdivision 2 in parens 2 of the same statute, 414.033. Now, the town does not have the power to object to this one. And this is one of the ones that we have identified as being rather problematic. This is one of the ones that we got one of the horror stories that I mentioned at the top of our presentation, in which it seems like the city in question just flat out decided to take this from the town and not bother telling them. That one came from this particular rule. Yeah, not great for us. The 120 acre method, 414.033 subdivision 2 in parens 3. City can annex up to 120 acres by ordinance if the land has to abut. Public wastewater facilities do not serve the land. All owners of the property must petition the city for annexation. And the land to be annexed must not be contiguous to any land owned by the same owners that was annexed under this statutory provision in the preceding 12 months. So basically, you can't use this one as an end run to get around the requirements of the bigger land ordinances. We don't have the power to object to this one. But of course, the landowners themselves have to actually petition for this one. That's in the statute itself. So even if the township per se doesn't have the right to kind of attack this process, it certainly is possible through the ordinary political process to try to attack it, because of course, if all the landowners don't petition, then it's not supposed to go forward. Okay, annexation of small lots, 414.033. Now, this one comes from subdivision 2 in parens 4, and it's got 3 requirements. The land has to have been approved by preliminary plot or final plot. It must have consist of residential lots that average 21,000 square feet or less, and it has to be within 2 square miles of the city limits. So this one does not require abutment. We have no power to object. Now this one is another one of a rare one. I've only seen this case come up in the docket about 4 or 5 times in the last 5 years. Now that doesn't mean that it wasn't used more often in the past, and I suspect that it likely was. But these tools fall in and out of fashion with the cities. So this one just doesn't seem to have been used very much lately anyway. Obviously, the no abutment requirement thing is a little bit scary, because it means they can reach out and create islands within your jurisdiction, theoretically. And we don't really have the power to object to this. So, it's another example of one that we would really like to see some movement on from the legislature. But it's not one of the primary vehicles of let's say, bad acts or problematic acts that I have been seeing in my own experience lately. Okay, platted or unplatted land containing up to 200 acres or less. This one comes from 414033 subdivision 5. A city may annex up to 200 acres of unplatted land or an unlimited amount of platted land if the majority of owners petition to have the land annexed to the city. So it has to be abutting to the city, but we do have the power to object, and you need a majority of the property owners petitioning. So once again, this is one of the ones in which, we do have the power to object, so that's nice. But there's also the landowners get a say, which I think all of us as agents of the democratic process are just inherently more comfortable with, especially since, if you really don't like this thing, you can go to your neighbors and say, hey, look, this is a terrible idea. Here's why. Vote against it. Please don't petition. So in the 120 acre method, yes. The question is from Pat Simberg, does the petition have to be all the landowners on the 120 acre method? And yes, that is in the statute. So this one comes from Minnesota statute 414.033 subdivision 2 in parens 3. And it does specifically say all of the owners have to petition. Now, one of my research projects on this is trying to go back and double check to see if there have been any shenanigans around this, because of course, it's good to. I have the same suspicion, Pat, but yes, that is written into the statute. Okay, 40 acres, 60% surrounded. This is another one that we've found some problems with, or I would say I have problems with. I think I can speak for the association on that one, though. So Minnesota statute 414033 subdivision 3, if the property is at least 60% surrounded by city limits and is not more than 40 acres inside, then the city may annex the property based on those 2 physical characteristics, basically. So this is one of the ones in which we have seen an example of the town just not liking, or the city just not liking what the town was doing with its land use restrictions, which is usually, hey, look, not bothering anybody, you can do it. And the town decided to be a NIMBY about it and just reached out and annexed the land to stop the landowner from doing what he wanted with his own property, which I think is real problematic, especially because of the fairly straightforward nature of this one. So this is one of the provisions that we're targeting. We call it the 40-60 rule. So if you've got any horror stories about this one, please, please, please let me know. So yes, we can object, but there's a big limitation in that, and I'll get to that in a minute. And then the last one that's pretty rare is an MPCA order for water quality. This one comes from a different statute. This is our first non-033. It's Minnesota statute 414.0335. And sometimes the Minnesota Pollution Control Agency basically just says, hey, look, these particular properties are way too polluting. We need you to connect it up to your city wastewater facilities in order to stop the pollution issue. I've never actually seen this one in the record. I'm sure it's happened. But at least going back in the last 5 years, I wasn't able to identify a case of this, which doesn't mean that they weren't using it for reasons that I can get into. But it does mean that it's at least a little bit hidden. Okay. So we have no right to object to methods 1 through 4 of the, wow, I can talk, really, I can, of the annexation by ordinance process. We do have a right to a hearing on 2 through 4. And probably the biggest right that we have comes from Minnesota Statute 414.036. If there is a final annexation order in a case like this, there has to be tax reimbursement. The amount that reimbursement is going to be set by the order, unless the city and the town agree to amount beforehand. So that's going to include your special assessments. It's going to include portion of debt attributable to the annexed property. If the ordinance is passed after August 1st, then the town can continue to levy on the annexed area for that levy year. Now, our hearings, we should talk a little bit about that. So if you're talking method 2 through 4, the city has to hold a hearing. It's the city's hearing. And they have to give at least 30 days written notice by certified mail to the following individuals or entities. So that the town or towns affected, all of the owners of the land, and all of the owners of the land contiguous to the area to be annexed. So they have to give you the opportunity for that hearing. But bottom line, when you are talking about this, there are some pretty, and this is kind of getting to the answer to Pat's question, in my view. There are some pretty serious limitations in the process right now on what the ALJ, that is the administrative law judge. When I called it a quasi-court earlier, it's because they're not actually a judge. It's an administrative office. It's an administrative office acting like a judge. Anyway, you don't have to care about that. It matters. It'll matter to your attorney if this ever comes up. But for all practical purposes, you can pretty much call them a judge and it's fine. If you hear an attorney use the term ALJ, that's where it comes from, administrative law judge. Anyway, so in issuing one of these orders, so say you've gotten into a fight with the city about this, the chief judge does not consider the annexation factors in contested cases. So there are possibilities, going back to our original triptych, there are possibilities to do annexations through contested cases, that is through court cases. And those court cases have factors under which we can fight back for obvious reasons. But the ALJ doesn't consider those. Instead, the review consists of confirming that the annexation is based on one of the authorities that we have mentioned in Minnesota Statute 414.033, that the proper procedures were in fact followed. So it's a pretty toothless review as things stand, which is one, in my view, of the problems that we are having here. Okay, so the question is, does the MPCA one have to abut the land, and is there a limit to the size? Now, this one's a little bit of a complicated one, and it's one of the areas in which I've done the least research. So my recollection is that no, it does not have to abut the land, and that there are size limits. But if you want me to be more precise about that, I certainly can be. Shoot me an email, give me a call afterwards. This was outside of the statute that So we were really targeting the 60/40 rule and the total surround rule. So I don't have those details at my fingertips. I do apologize for that. All right. Here is, I think, the bottom line for my presentation this morning. I think this is a prime area for a push on the reform side. I think if we can get our township officers to give legislators a call and give them their views on this, then we can get a process that at least gives us a fighting chance in these cases. Until we get a formal proposal before the legislature, it's a little difficult to say what that would look like, but certainly more robust review by the ALJ, certainly, some input from the landowners, more room for the town board to object. Just please, if you've got time, this isn't like A1 urgent business or anything like that. Not trying to put a gun to your head or anything, but if you've got the time, drop your legislator an email, give them a call, say, hey, what's up? Can we do something more fair than this, for Pete's sake? At least that's my view. That's my view anyway. So, okie dokie. We've kind of been fielding questions throughout here, which is the practice as I like it. I think it's a lot easier to keep everybody on the same page if we do it that way. But does anybody have any questions here in the meantime? Going once, going twice. All right. Well, in any event, it was a pleasure to see all of your faces this morning. I hope you found this of some value at least. And if you have the horror stories, give them to me. All right. Well, that was all I had for you guys. So in that case, thank you very much for attending, and have a good morning, everyone.
Thanks, Graham.